Tao, am I pronouncing it? Tao, and Chris Rasmussen on the floor. This is our panel here for you, gentlemen, and we're going to get right into it by moving on to Mr. William Brown. Oh, I'm sorry, you know what? Mr. Dan Barry.
Yes.
We'll go with you first.
Okay.
It's your next one over. So, Mr. Barry, you have the floor.
Oh, great. Thank you very much. First of all, thank you very much for showing up today, and I respect what you do very much. The war on drugs going on now since probably the early 1990s, and I think we're seeing with our high incarceration number in prisons that the argument between the philosophy of rehabilitation versus philosophy of incarceration is really at odds. What do you think we do to increase rehabilitation in our present cases? That's very good, challenge.
And before we answer, gentlemen, if you could just please limit, because we only have a certain amount of time, if we could limit our answers to under a minute for now, would be nice.
Sure.
Thank you.
All right, well, if I can start, that's an interesting question. I had been on bench for a year, and prior to that, I was a prosecutor in the Clark County District Attorney's Office for several years. I was also a chief deputy in the Public Defender's Office right before I got appointed. And so I've seen drug cases on both sides. I've prosecuted them, and I've also defended people who were accused or arrested and charged with possessing or selling drugs. It's interesting because as a judge, I have a split docket, meaning 50% civil, 50% criminal. In the criminal cases, I've never done a study, but something like, just my anecdotal evidence, easily a majority of the cases that appear in front of me are drug-related in some way. They either are cases about possessing drugs or selling drugs, or someone was stealing to support their drug habit, or in some cases they're committing more violent crimes because they're under the influence of drugs, or they are trying to obtain property in order to support their drug habit. So it's a serious problem. I think that in cases of, well, if somebody, let me back up, let me divide my answer up into two halves. If somebody commits a violent crime, if they're out committing a gun robbery at a 7-Eleven, to me it matters a little bit whether or not they were under the influence of drugs, or maybe they were stealing to support their drug habit. But in the end, they've committed a very serious, dangerous crime that could have resulted in people being injured very seriously. And those people, in most cases, depending on the facts, probably deserve to go to prison or at least some serious penalty. On the other end of the spectrum, though, are people who are arrested for simple possession of drugs. Somebody is addicted to drugs, and they haven't committed any other crimes. They just have drugs because that's what they do to support their habit. In those cases, you see, unfortunately, a lot of those cases, a lot of them. Drugs are just a serious problem. And those people, by and large, depending obviously on their past record and those kinds of things, if all they've done is be on drugs and try to obtain drugs, they really don't belong in prison. It's not going to do anything for them. They're going to come out, they're still going to be addicted to drugs, and they're still going to commit the same crimes over and over again, which is they're trying to get drugs because they're addicted to it. Fortunately, in Clark County, we have one of the most well-known and most admired drug court programs in the country. It does a good job for people who qualify to get in. It has, it's a tough program. A lot of people don't make it, but those who do make it, the recidivism rate is really, really low. Most people who graduate don't show up in the system again. And so there's proof that that system works, and it's very valuable. And it's better not to have somebody come back in the system than send them to prison and not treat their addiction and just see them over and over again, and eventually they just serve their lives out in prison. I'm a big fan of drug court. I send a lot of people to drug court. I listened to the previous panel. I know that one question that was asked by somebody related to Veterans Court. I know in 2009, the legislature passed a bill to expand, to create a Veterans Court, which functions with Mental Health Court and Veterans Court. And I think that's very valuable. I think, oh, I'm sorry, I'm seeing the time. I was going to say, if I could just get 10 seconds. I do see a lot of veterans who are addicted to drugs, some of them because they've left the service with serious psychological disabilities, and they self-medicate. They take marijuana or something to make themselves feel better because of their disability or their psychological impairment. And those people definitely don't belong in prison. They've served our country, they've suffered a mental health issue because of it, and the last thing we should do is punishment. We need to punish them. We need to get them help if we can, and if the facts are appropriate, and I'm a big fan of those programs.
Hi, good afternoon. I'm Chris Rasmussen.
And could you just tell us a little bit about yourself before you answer the question, please?
I'm a lifelong resident here. My practice consists of 50% criminal, 50% civil. I've handled all types of cases on both ends of the spectrum. With regards to your the war on drugs questions, I think I've had thousands of people sit in my office. I've represented people that are members of cartels in federal drug cases, all the way down to young people sitting in parks smoking marijuana. I think we can, as well as Mr. Tao, Judge Tao, we can tell pretty quickly people that have a drug problem that can be handled, or people that are taking advantage of the system and selling large amounts or large quantities of narcotics. So we do have the tools in place with the drug court, and also our state has a statute, NRS 453-3363, that allows for a diversionary program to allow drug offenders to receive a dismissal and a sealing of their record if they complete drug counseling. So there's definitely tools available out there, and we can help people that need to be helped, and we can, put people in prison that are causing too much of a ruckus out in our communities. So I think there's the appropriate carrot and stick there.
Would you like a beep at 50 seconds?
Yeah, that'd be nice. And then, thank you very much, Mr. Varian. We'll bump it back right to Ms. Howard, because she was grabbing something for us real quick.
Really, my question is probably going to be just for Mr. Rasmussen. Judge Tao went through an extensive vetting process in terms of getting appointed by Governor Sandoval, and he had to fill out a 10, 20, 30-page application, go through numerous interviews. 5-page application. I'm just kind of curious. He was appointed just 2 years ago or a year ago, and you're running against him. Would you be willing to fill out that same application and put it on your website so that the voters can decide?
Absolutely.
Wow, that was good. No spin on that one. That was awesome. Thank you very much.
Well, if I could, answer a little bit of
If
your
you
question.
elaborate, that's fine.
The appointment process is a very closed-door process. The county commission gets together behind
Right.
closed doors, submits people to the governor. It doesn't allow the voters a chance. And in our state, I grew up here. Our state prides itself in our process where we elect them. And folks like you and people out there now with the internet, they can get educated on the candidates and our race and see who they like. And there's plenty of ways. I think the electoral process is a better way. It lets the people decide in a transparent fashion.
If I could just pipe in, that's absolutely not true. My interview with the Judicial Selection Commission and the deliberations were podcast and were open to the public, and so the whole thing was publicized. The only part of it, there was a short 5-minute section at the end when they talk about financial information, which obviously is not publicized because they're talking about bank account numbers and that kind of things as part of the background investigation. But it's as open as it can possibly be. You can actually get, to this day, off the Supreme Court's website, the podcast of my interview, which you couldn't in most other political debates or interviews.
Okay.
And then, go ahead. Ralph?
Thank you. My name is Will Brown. Thank you both for being here. My question relates to criminal law, criminal procedure maybe. Judges are required to apply the law, especially the Constitution, even when it means an unpopular result. When it means suppressing evidence, when it means dismissing a criminal case. Those type of decisions are unpopular, and at least for me would be very difficult to make because they're unpopular, especially in light of the fact that judges are popularly elected. I don't think I'm saying anything that anyone doesn't know when I'm saying that an endorsement from a law enforcement organization carries a lot of weight in a judicial race. In instances where the Constitution clearly requires that charges be dismissed or evidence be suppressed, what are the beliefs or values or experiences or people that you rely upon making the right decision, even when it is going to be an unpopular decision?
Well, when you get into office, you take an oath to uphold the law. That's the job. And if you can't do that, regardless of whether or not it's popular or unpopular, then you shouldn't want to be a judge. You should go do something else if what you're after, maybe be a congressman or something, if you think that your goal in life is to be popular in the community. It's what the job is. And you're right, it's in this state we do elect judges, and so sometimes there is a tension between what's the right thing to do in a particular case and how it might play in the press. But you have to put that aside. The job is to uphold the law, I've made decisions since taking the bench that were tough calls, some of which I knew wouldn't be popular, but it's what the law required. And the hope is that when I stand for election this year, that the voters will keep in mind that, okay, look, maybe I didn't do the thing that everybody wanted me to do, but it's what the law required me to do, and I at least had the courage to do what I thought was the right thing. And hopefully that will at least carry some weight with the public.
I think you're asking specifically about the Fourth Amendment type issue, search and seizure. As a practitioner in criminal defense, I filed hundreds of motions to suppress, very few are granted. And I think, you know, it's obviously up to the attorneys that practice in front of the judge to bring out the facts, because these type of motions, they are very factually driven, how the officer communicated to the people charged, the defendants. There's a lot of factual things. So I think a lot of times it is a tough call and it's a close call, but obviously I think I would be able to make that call because of my experience practicing criminal defense, and I don't think it's a concern to any judge whether it's popular or not.
We'll go back down to the end.
Thank you for coming out today. Currently, before the Supreme Court is a case called U.S. versus Alvarez. In the stolen valor issue, Congress passed a law basically making it a crime to pretend that you're a service member. And Mr. Alvarez, in the case, was the defendant, was charged and convicted for claiming, and he was never a Marine, he never rescued an ambassador, never received a Purple Heart or Medal of Honor. The question to you is, it will be decided at the Supreme Court, but prior to that now, where would you fall as far as, does this fall in the protection of the First Amendment, or does Congress have an interest in protecting the integrity of the medals system? Your Honor.
Well, I'm not 100% familiar with the case. I do know what I read about it in the newspaper, and it's really interesting. I do think, on the one hand, I understand the purpose of the law, which is that there are people out there who are falsely professing to have served our country. And I think in this case, he not only said that he's falsely served in the military, but he received a bunch of medals and served in combat, and things that really would be things that are earned. I do understand the impulse that is demeaning to those people who actually did serve and put their lives on the line for the rest of us. But obviously, however the Supreme Court comes out on it, as a judge, I'm bound to follow it. They are a higher court, they claim what the law is, and once they issue their decision, my job then becomes to enforce it fairly and impartially. But the First Amendment is a balancing test, and that's what makes these cases tough. It's not an absolute thing. It's, on the one hand, what are the interests at stake? On the other hand, what you weigh that against the individual's right to engage in free speech, even speech that's false. And so I'm extremely interested to see how they come out on that.
This is actually a federal statute that wouldn't apply to the state courts. However, I think there should be a line drawn between, we see homeless people saying, I'm a combat vet, I need food, compared to people like in Alvarez where they're trying to get some type of pecuniary gain with this false statement. And I think the statute addresses that. I think the Supreme Court will uphold it, and I would support that.
Thank you very much.
I'm up.
Yep.
Morning, gentlemen. Morning. Judge Tao, are you aware of any statute that allows a criminal defendant to obtain fees and costs in the event that he was prosecuted without probable cause?
There's, as far as I know, there's no statute that automatically allows that. However, if someone really was wrongly prosecuted, he could, in theory, sue the state under what's called a Bivens claim. We don't get a lot of those. It goes to the judge, it goes to the jury, and so you, in theory, can recover for damages under that avenue. But as far as I know, there's no statute that automatically allows me to assess costs, like I can, for example, in a civil case.
With a Bivens action, you can sue a prosecutor, but the hurdle you have to get over is pretty high. I've been involved in litigation in federal court involving that. Prosecutors, the first step is to have the prosecutor's immunity stripped away from them. It's a high standard. You have to show some kind of conscious disregard for the defendant's rights. So there are remedies available, but it's a high hurdle.
Do you have a pen? Do you have a pen?
No.
Neither of you have a pen. Would you write down the statute for me? NRS 176.115.
Hang on, I can look it up.
There actually is a statute. It's never been tested. There's no case law on it. And it's not suing, the recovery is not against the
You said,
prosecutor.
I'm looking at 176 what?
0.115.
176.115?
And so it's kind of a trick question set up because it's never been tested, it's never invoked, but, and the recovery is not against the prosecutor, so it's not a business case. And so, educational moment.
Recovery
From the complainant, meaning the prosecuting jurisdiction.
Yeah, but, if.
Check it out.
No, I'm looking at it right now. Nobody seems to know about it. I've been a
Correct.
prosecutor for many years. I was a defense attorney as well. I've been a judge for 14 months. I've never heard of that, and so if I don't know about it, I'm sure people whose rights have been violated don't know about it. Maybe, someone ought to publicize it.
I have a case up in front of the Supreme Court right now.
Okay.
We know, I asked defense attorneys, can you get fees and costs, and everybody said no. Well, it turns out there is a statute.
Right. Well, if the Supreme Court publishes an opinion, then everyone will know about it, so maybe that's a good thing.
Or we'll just take out a billboard ad.
Thanks.
Thank you, Janice.
Hi, good afternoon, gentlemen. I'll just keep the same question for both, if you don't mind, if that's all right. I would like to know now, how do you intend, or how have you in the past funded your campaign for judge? And will you take campaign donations from law firms or individual attorneys? And if so, how would you disclose that information? If not, perhaps recuse yourself from any trials where said law firms or attorneys are seeking your judgment in case?
Sure. I think, obviously, I've taken funds in my campaign from other lawyers that could potentially practice in front of you. The state and the county and the federal government have very strict guidelines, reporting guidelines, so every dollar we collect, we have to report, and it's public record. You can go on the websites, the county website, the state website. You can see exactly for campaigns a long time back who actually gave to that campaign. I think there are some cases where we've seen in the newspaper where there's been a large sum of money from one lawyer to a judge, and it's unusual. Those, I think, would cause concern, but I think for the most part, our campaigns are set up where, lawyers give a fair amount, nothing extreme, and I think it's very transparent. People can see if there's something like that going on.
Well, the reality is most people don't pay attention to judicial elections, and that's a shame. People should. And so the reality is most of the people who give money to judges and judicial candidates are lawyers and law firms. That's just the reality, and it's legal under our system. I know that one of the issues that was on the ballot last election cycle was whether or not judges should be appointed instead of being elected, and this is one of the arguments why they should be appointed, because essentially you seek and take money from lawyers who appear in front of you sometimes regularly. And as a judge, I can say I try very, very hard to separate whether someone is giving me money from the merits of the case. As indicated in response to the other question, my job is to do what's right, to follow the law, regardless of whether it's popular, regardless of whether or not a particular party gave me money. But I do think it certainly suggests an appearance of impropriety. If somebody thinks that I'm ruling in favor of somebody who gave me money, whether or not that has anything to do with my decision, it certainly undermines confidence in the judiciary. But it's the system we have, and it's what our laws say, and unless we want to have some sort of public funding, I'm sorry, I'm a little language, public funding of campaigns, or unless we prohibit judges from raising money, that's the way the system works.
Thank you both for coming up on the panel today. I have a separate question for each one of the candidates. Judge Tao, I'm going to kind of piggyback on Rob's question here. You said that if the Supreme Court upholds this law, that of course you will uphold the Supreme Court's decision, which is obvious you have to. Do you personally believe that Mr. Alvarez, if it is upheld, he has a First Amendment right to basically?
Well, that's an interesting question. The First Amendment protects all speech, whether or not it's true, because as the Supreme Court has said in the past, the remedy for speech, or what they say is bad speech, is more speech. You know, if we get to this stage where we are criminally prosecuting people for telling untruths, we're all in trouble. Everybody who's ever cheated on their spouses is in trouble. Everybody who's ever told a white lie to make somebody feel better is in big trouble, and that's a very, very, very dangerous place to be. You're essentially living in a communist society at that stage, where the government's monitoring what you say. So in this case, though, what we're talking about is at least the potential for it's beyond really whether or not he's lying. I don't think we should prosecute people for lying. However, in this case, there may be real harm in that he is obtaining benefits from other people who falsely believe his lies. And in that case, the First Amendment gives a little bit less protection for very obvious reasons, because there's a very public harm involved. But I see my speakers, so I'll cut it short.
Thank you very much, Judge. Okay, and then the next question is for Mr. Rasmussen. What is Judge Tao doing wrong and why? Otherwise, you wouldn't run against him, right? He's got to be.
No, that's definitely not true. I've known Judge Tao when he was a prosecutor and a public defender. I know him to be a very honest and decent man away from the court, and a very bright person and a good lawyer. So it's nothing to do with him personally. He's only been on the bench maybe a year. I haven't done any trials in there. I don't know enough about his courtroom. The reason I put my name on the ballot is I strongly believe the voters should have the opportunity to elect somebody. I think too often we see judges run unopposed, and I don't think that's proper, because I think people in Nevada have the opportunity to vote, and they should vote. Everybody should have an opponent and hash out these issues every 6 years and just make sure somebody's doing a good job. And that's why I ran. It had nothing to do with him personally. I've only known him to be a gentleman and a very bright lawyer.
What do you, if elected, what do you want to do?
There's one judge that I've always admired in the court, and I know some of the defense attorneys probably would disagree with me. There was a judge who's getting ready to retire. His name's Donald Mosley. And Judge Mosley is, I practiced in this court a long time. He's a very tough judge on defendants, but he's very consistent. He's very common sense with his approach. People know right away, lawyers, when I'm consulting with a client, I know it's Judge Mosley, I know the crime, I can tell my client exactly what's going to happen. He's always consistent down the line, and I appreciate that in a judge. And I would try to run my courtroom the way Don Mosley's run his courtroom.
Okay, thank you very much.
I'll run back with something I asked earlier that gets a raw nerves with attorneys. The WizNet system, and again, this is a contract entered to by the clerk, the judicial clerk, to do part of the court's work. The clerk is hired now by the judges rather than automatically being the county clerk. What can the court do to make that system more reasonable, more effective?
That's an interesting question. I get complaints about the WizNet system all the time. I can't even tell you how many times since taking the bench I've had motions come up where a couple days before the hearing date, it turns out the motion wasn't filed, or maybe the first 10 pages the motion filed, but not the last 5 pages, and then it becomes a mess. You know, it's a whole, I don't know if the issue is budgeting or what. WizNet's not even the worst. There's a system that the Metro Police use called Scope, which is not even Windows-based, it's DOS-based. You know, so I don't know what the reason for that is. Maybe it's cheaper that way, maybe they haven't upgraded it in 20 years, but you know, it's a serious problem, because especially with, it's a problem with law firms that are paid a lot of money. It's especially a problem with pro-per defendants, people who are filing petitions on their own, where they don't have the resources possibly to check on their filings and make sure all the pages were there. It's a real problem. I've had to continue hearings because of things that the attorneys thought were filed and weren't filed, or were incompletely filed, or when I try to pull it up, I can't read it because it was scanned in improperly. It's huge. Fortunately, it's not a huge problem. The majority of filings, and probably the overwhelming majority, get through, but it's a big enough problem that I've definitely noticed it. Sorry.
I agree, we should scrap WizNet. And the thing with it that's so interesting is right across the street from the federal court, they use a system called PACER and CMF. It's a great system. Anybody that's practiced in the federal courts, it emails everybody the updates, and you get something back as soon as you file it, an email with a stamped copy. It's a great system. Maybe it's too expensive, I just don't know. But I know there's a better system out there, and we should try to strive for that.
So switch systems.
Absolutely.
Yeah, WizNet's the only thing that's ever gotten me to say nice things about PACER and ECF.
And we'll finish up here with Ms. Yonobi.
Okay, I'm going to go back to one of the original questions about drug use and drug court. I have a 20-year-old brother who is in college at UNR, and I know that he is a recreational user of marijuana and alcohol. Do you take that into consideration when these kids come in front of you in the court that they're not, I certainly don't think he has an addiction, he's 20 years old, he's on his own in college. So is that something that you consider when they come forward with like a possession use charge or something like that?
Usually cases like that, recreational drugs don't make it to the district court. They're resolved at the justice court level, usually with a fine, a class on the internet, and a dismissal at the end to keep the record clean. We can, as lawyers, as judges, we're pretty good at identifying people that are just recreational or trafficking. I mean, it's pretty simple, and I think everybody would agree somebody like your brother should, you know, receive counseling before he's put in the criminal justice system.
Right, I would agree with that. You know, we look at, when we sentence people, when I sentence people, there's a variety of factors I look at. Age is obviously a huge one. There's a big difference between an 18-year-old who's doing marijuana versus a 20-year-old who's, you know, out robbing banks. There's a, you know, it's not just age, but the crime, but also age. And you know, people do things when they're young. They experiment. They make poor judgment calls. That's the price of being young. We were all there. So I look at age, I look at does he have any prior criminal record. If he's, you know, if this is his first offense, then obviously that's a huge consideration. You know, I don't want to ruin his future because of a mistake he made when he was 18, so that down the line he can't get a job or those kinds of things. So in the specific case of, and I'm going to call him your hypothetical brother, so that I don't have to take that as an admission that he's committing crimes, but your hypothetical brother, in that case, if he's an 18-year-old college kid who's doing marijuana, first of all, I would hope that he wouldn't even end up in the system, that maybe the police would cut him a break, but if he does end up in front of me, I would give him every break possible, because he's a young kid doing things. Yes, it's a crime, and there ought to be some consequence, but it shouldn't be the most serious consequence if that's all that it is.
Well, we got through the whole panel this time. That was great. Thank you. Thank you for keeping time and keeping everybody in check. And gentlemen, we want to thank you so much for once again making yourselves available for
Thank you for having us.